Okay, we are good. We have everybody, and counsel for the appellant, you are able to proceed at this time.
Thank you, Your Honor. Good afternoon, and may it please the court. I'm Robert Finger on behalf of Tank Tech, Inc. We're here following the trial court's granting of summary judgment on equitable subrogation, which follows this court's 2018 opinion, which reversed and remanded summary judgment on Tank Tech's equitable estoppel claim. The trial court's summary judgment order should be reversed for at least 5 reasons. First, faced with an equitable subrogation claim, the court should focus on resolving the equities and reaching a just result. Next, a release is not required for equitable subrogation where the underlying claim is not in tort. This case has an underlying claim of contracts, as this court has already found that a contract existed between Valley Tank and Circle K. Next, appellee failed to prove that Circle K did not.
Finger, can you get a little closer to your microphone or speak up? I don't know if the other judges are having a hard time, but I need a little more volume if you got it.
How's that, Your Honor? Your Honor?
Are you just as close as you can get?
Do you have the ability to raise the volume on your computer or on your speakers, or how it works?
I am working on it. You're testing my technological capabilities.
I'm not one to throw any stones, trust me. I'm just asking.
Is that any better, Your Honor?
That's a little better.
Okay, thank you. A release, as I said, a release is not required where the underlying claim is in contract and not in tort. And this court has already found the existence of such a contract between Circle K and Tank Tech. I'm sorry, between Circle K and Valley. Next, the entire debt must be examined on a tank-by-tank basis. Each damaged tank is a separate cause of action. Also, the entire debt does not encompass tanks that either weren't damaged or where Tank Tech did not pay for damages because no claim had been made for damages at the time this litigation ensued. So the only way to measure the entire debt in this case is tank by tank severally for the 115 tanks that are at issue in the case. Finally, appellee did not meet its burden of showing the damages on any tank or tanks were not fully paid. Mr. Russell, the president of Tank Tech, testified that all the invoices presented by Circle K were paid, and even Circle K's witness, who was presented by Valley, testified that he wasn't aware of any unpaid claims. So for purposes of summary judgment, appellee could not demonstrate that the entire debt had not been paid.
Judge Kelly, you'll need to unmic.
Yeah, thanks. Thank you. Sorry. I have a question. You were up here once already after a motion for summary judgment. And then when you went back, Valley Tank just filed a renewed motion and asserted a different grounds, this time the discharge of the entire debt. Could that have been raised in the first motion for summary judgment?
Yes, Your Honor.
Okay.
They also raised the absence of a release, and that certainly could have been raised in the first motion as well.
Both of those, yeah, I feel a little bit like we're, and believe me, I've tried to find a way that, that is relevant to this case, but I feel a little bit like it's whack-a-mole here. Are we just going to do every element, go back, and we're going to try a new element the next time? So, but as far as you're concerned, there's no reason this couldn't have been raised in the initial motion for summary judgment.
That's correct, Your Honor. And in fact, if you
Any new facts discovered or something happened. Okay. All right. My second question is, well, go ahead. I'll save the second one for.
Okay.
Go ahead.
To your point, Your Honor, I think it's that the first panel really did address that matter, recognized that a release wasn't even a consideration in this case, and said, if Tank Tech is ultimately successful in proving that Valley Tank caused the damage to the USTs, then it would be entitled to seek any damages it incurred as a result of having to repair the damaged USTs. If they were concerned about a release, they would have said something. But obviously,
Well, maybe not. I don't think anyone argued that.
well, but on the flip side, Your Honor, this isn't a tort case. It's certainly not the prototypical tort case. It's not a tort case at all.
No. No. Oh, well, as long as I'm moving you off what you had planned to argue to satisfy my curiosity. The other thing I didn't really see discussed that I'm curious about is, it's alluded to. Valley Tank alludes to, well, we could be liable. Well, how? I mean, part of the subrogation claim is that you're asserting is that Valley Tank should be primarily liable. But yet you have a contract that obligates Tank Tech to repair. So how would Valley Tank have been, under what theory would they have been primarily liable?
I don't think there is such a theory, Your Honor, and certainly based on the findings.
Well, isn't that essential for your subrogation claim?
I'm sorry, Your Honor. Maybe I misunderstood. Valley,
one of the elements of subrogation is that the subrogee is not primarily liable for the debt.
Well, the
So that
subrogee
would
is,
mean to me, Valley Tank would be primarily liable, but you've stepped in, you've paid the debt, and now you want to recover it in, under really a restitution theory from Valley Tank. But and Valley Tank keeps saying, yeah, they could come back and sue us, but neither Valley Tank nor Tank Tech has explained under what theory and why. Why would Valley Tank be sued?
well, Valley
I think
Tank,
you both need to explain that.
well, if Valley Tank, well, first of all, this court has already found that there is sufficient evidence in the record to move forward on the argument that Valley Tank is primarily liable. So that issue is set in.
Well, they said there's a disputed issue of fact
Correct.
as to whether what Valley Tank did caused the damages.
That's correct.
Right.
And so if they did, and we think they're primarily liable for it, that's obviously the heart of our case, then the question that has to be asked is, could they face any additional claims from Circle K who was damaged?
Well, let me just stop you for a second, because if you have a contract with Circle K that obligates you to repair the tanks regardless of the cause of the issue with the tanks, wouldn't that make you primarily liable?
Well, Your Honor, that's not an absolute statement of liability in terms of that contract. Also, the contract actually had two parts. One, for a period of time, we were liable to repair those tanks. And even with that liability, this court has found that did not convert us into being a volunteer, that we had a legal.
No, you were contractually obligated to do it. That's my point.
Well, Your Honor, an insurance company is contractually obligated to pay damages. That doesn't interfere with its subrogation rights, conventional or equitable. And if it did, we would probably never have subrogation in an insurance context.
Okay. All right.
What has to be remembered is equitable subrogation is Tank Tech's only remedy in this case. And Your Honor, what the court said in the first Tank Tech case is, quote, to hold that Tank Tech is precluded from pursuing a claim for subrogation would leave Tank Tech without a remedy a most unfair and inequitable result. And Judge Kelly, as you wrote in the State Farm case, and again, realizing that that was a tort case, and we do have the issue of a release, which we don't have here, but nonetheless, you wrote, the doctrine is based on the policy that no person should benefit by another's loss and that equitable subrogation may be invoked whenever justice demands its application, irrespective of technical legal rules. If in fact the issue on summary judgment was whether or not Circle K had given a release, Valley did not establish the absence of a release. Valley's motion was accompanied by the affidavit of Circle K's environmental manager, who, even though he said in his affidavit that he had personal knowledge of the matters, in deposition admitted that in fact he had no personal knowledge of these matters, wasn't an employee of Circle K at the time the events occurred, and conducted no investigation to determine whether Circle K had been requested to issue a release or whether a release in fact was issued. But setting that matter aside, the fact of the matter is no release is required outside of the prototypical tort context. And that's what the Supreme Court said in the WQBA case when it said there can be no doubt, where the WQBA case added the release requirement to equitable subrogation and said in the present case, equitable subrogation would only be proper if it can be established that Three Kings pay the entire debt owed to the plaintiff, and that in doing so, Three Kings obtained a release for Dade County School Board from the plaintiff. Now, this court followed the WQBA case in a couple of cases. One, in the Welch case, which was written by Judge Northcutt, who sat on the Tank Tech panel, said WQBA further limited the doctrine in tort cases to situations where the party seeking subrogation has obtained a release for the other party responsible for the debt. And then Judge Kelly, you wrote in State Farm, in tort cases, the party seeking subrogation must have obtained a release for the debt. And then the Supreme Court followed with the Holmes Regional Medical case involving successive torts, and also based on WQBA, said that a release was required in a tort case. So the courts have not stated a policy reason for this, but let me suggest that because in the prototypical tort case, which is a personal injury case, the plaintiff might typically have non-economic damages, such as pain and suffering or loss of consortium. And so without a release, we can never really be sure that the plaintiff has been fully compensated. In a contracts case such as this one, that simply isn't an issue. And that's why we can't find, and Appellee hasn't found, a single non-tort case where the courts have required a release. We can start with the Evanston case, where the court said, the court agrees with Evanston that the existence of a release or an assignment of claims are not necessary predicates to prevailing on a claim for equitable subrogation. And the court was aware of the WQBA case. It cited it in the very next sentence to that quotation. We can point to a panoply of non-tort cases, and we did so in our briefs, but the fact of the matter is a release is not required in a non-tort case. This is a non-tort case. That would have been the nature of the underlying claim between Circle K and Valley. To show you where courts will go to try to resolve the equities, the Novelsky case is an interesting case. The court was trying to prevent unjust enrichment by way of a double payment in a property damage case. And even though that case involved a tort, the court allowed intervention even though the insurance company had only paid the claims presented by its insureds by saying they paid their entire contractual obligations to the insureds based on what the insureds represented as their total proof of loss. Well, in this case, we also paid the total proof of loss. Circle K gave us invoices. We paid those invoices. Mr. Russell testified by affidavit that all of those invoices were paid. And Circle K's witness, who was presented by Valley, stated that he wasn't aware of any other claims. And so clearly, if there were additional claims, Valley has not presented any additional proof of what those claims might be. Let me turn to the entire debt question.
You are at 15:45.
Thank you, Your Honor. I'll eat into my time briefly. Each of the tanks, each of the 115 tanks at issue in this case is a separate cause of action. We could have sued for one, we could have sued for a dozen, we could have sued for all of them. Mr. Russell testified by affidavit that he paid invoices with respect to all 115 claims. Valley would like to bring in subsequent claims that may have arisen between Circle K and Tank Tech, but none of those claims involve the 115 tanks that are at issue in the underlying litigation. And so none of them are relevant. We haven't paid any debt. None of them are relevant to this equitable subrogation claim involving any one or more of the 115 tanks at issue. Thank you.
We are ready, counsel, for the appellee. You may proceed.
Good afternoon. Good afternoon, may it please the court. The judgment should be upheld as Tank Tech failed to present record evidence sufficient to reveal a genuine material fact. Further, there's no record evidence that Tank Tech paid the debt of Circle K in full. There has not been any discharge or release of any debt of Circle K. And it's important in a case like this where there are unliquidated damages that are not specifically defined to ensure that all of the claims of Circle K are paid in full. It's interesting to note that there's a claim that each tank is a separate cause of action. However, there were clearly not 115 causes of action alleged in the complaint or in the amended complaint. All of the tanks were lumped together and sought an unliquidated amount of damages, just solely an amount that exceeded the jurisdictional limit. And what the affidavit of Mr. Russell stated, and it's in the record at 4927 to 34, was that Mr. Russell says he approved and paid invoices that were sent by Circle K. As the court's well aware, we have a contract between Circle K and Valley and a contract between Circle K and Tank Tech, two separate contracts. And so regardless of whether or not Tank Tech paid invoices that were submitted by Circle K, there's no record evidence that Tank Tech discharged any claim or debt that Circle K might have against Valley Tank.
I want to stop you right there because, you know, it seems like your argument's a little inconsistent. You say, well, there, you know, there's no evidence they discharged any obligation of ours. And then the other hand, you're saying, hey, Circle K could come back and sue us. Well, which is it? Is it your obligation or not?
Well, Judge Kelly, the issue is that Circle K had a contract with Tank Tech. Circle K had a contract with Valley. Circle K has never brought a direct claim against Valley pursuant to that contract, right? Tank
No,
Tech,
but you keep raising the specter that they could, unless you have a release.
right. And what happened is in the related case that we filed, notice related case, Circle K actually did bring claims in state court against Tank Tech. And those type of unknown claims
no,
that could
no,
still
no,
be
no.
out there and present that Circle K
You
could.
keep, I'm sorry, maybe I wasn't clear. I think Valley Tank keeps asserting that, hey, you know what? Circle K could come sue us unless there's a release. Could come sue Valley Tank unless there's a release. They got to get a release. But then you're saying, well, there was no obligation for Valley Tank. So, you know, which I feel like that's inconsistent. Can you help me with that?
Well, obviously, if Circle K had a contractual claim against Valley Tank, they could have brought that directly against Valley Tank. Correct.
Right.
So Circle K then, through its contractual relationship with Tank Tech, has said, Tank Tech, you need to repair tanks.
Right.
And Tank Tech said, okay, we're going to pay you to repair the tanks. Tank Tech then says, okay, we think really Valley should pay us for those repairs. And so we are going to bring multiple causes of action.
I understand that. And I mean, that's the nature of equitable. That's the nature of equitable subrogation. It's really a form of restitution. Tank Tech's position is, hey, you know what? Valley Tank didn't do this testing properly. It damaged the tanks. Now, because of our contract with Circle K, we've got to fix it all. And we shouldn't have to fix it because it's really not our fault, but we're doing it because we have this contract. And so we paid this money. And now, hey, you know, Valley Tank, we want you to reimburse us for that, what we have paid, that really you should have paid because it was your work that caused the issue.
And here, the problem is that there's no certainty or no evidence from Circle K, who would be the one to best say whether or not the invoices that were paid were all of their damages or not, right? They just say we paid whatever Circle K sent us. And we know by the fact that Circle K continued to bring claims against Tank Tech that there were other issues that Circle K had with Tank Tech.
But they're not trying to recover for those.
Our affidavit.
Wait. They're not trying to recover for those in this case, are they?
Well, we
I mean, there's a
know.
finite set of tanks that they repaired at their expense that they want to recover for. Not, hey, any tank ever that we have to repair for Circle K.
So their pleading, right, is very vague as to what are the tanks at issue. It's these tanks from independent operators, and all other tanks that could have been damaged. They don't specifically, although there were attachments to the complaint.
That's why you have a trial.
So Your Honor, there's definitely no certainty.
They're going to have to come in and they're going to have to prove, hey, this tank was damaged for this reason. That was Valley Tank's fault. Here's what it cost us to repair it. Valley Tank should have to reimburse us for what that cost. And then Valley Tank can say, hey, no. That wasn't our fault that was damaged. And you know, then a jury gets to decide, or a judge gets to decide if you do it without a jury. Why is this not a case that just goes to trial?
Because they've failed to establish that they can meet all the elements of the claim of equitable subrogation. The trial court clearly found that they did not present record evidence to show that the entire claim of Circle K was paid in full, discharged, or released. We are saying that when you have an unliquidated amount that is uncertain and not clear.
Well, let me just stop you there. What would be Circle K's obligation? What would Circle K's debt be that you claim should be? They need to prove that they have entirely discharged Circle K's obligation. What is Circle K's obligation that they need to prove should have been discharged?
Your Honor, if you take the converse of that, it's clearly that they have
No,
not gotten
please,
Circle
let's
K
start
to
with my question. Just start with my question.
say,
And we'll do converse.
okay, so Judge, I don't know what other damages Circle K could have. Okay, I'm
But they're
being
supposed
asked
to prove that Circle K doesn't have any?
they are supposed to show that any claims that they want to stand, that it's a full discharge and satisfaction. And the problem is, as you have these tanks that go in and out of service, they have obviously popped up since the time of the filing of the lawsuit, and Circle K has come back and said, hey, you've
Well, they
got
haven't
more things
sued
to
you for,
fix.
have they
Our
sued you for
affidavit
those?
attached letters saying,
I'm
no,
trying
because I
to
don't
stick
think
with
Circle
what's in
K
this
thinks we did
lawsuit.
anything wrong.
Well, then then they don't get subrogation. But you proved that at trial. I mean, there's two things. Number one, whose fault was this? Who's responsible for the damage to these tanks? That's part one. And if it turns out that Valley Tank is not responsible, that's it. You're finished. But if it turns out that really it is Valley Tank's responsibility, and that in fairness and equity, Tank Tech shouldn't have had to pay for these repairs and should be reimbursed, that's a separate question.
So how do we even know what Tank Tech is alleging are all of their damages? They have never liquidated, never set it forth in the record up until this point, despite various discovery issues.
Well, I
yet they
think
wanna
that's
go-
I think that's what a trial is for.
But if they can't liquidate the amount, there's no way to say that they've discharged or paid it in full. You can't get to
Okay,
one without the
that
other.
brings
It's
me
a chicken
back.
and egg.
Okay, that brings me back to my question. You keep saying they have to prove that it was discharged and paid in full. What was discharged and paid in full? What do they have to prove was discharged and paid in full?
Any claims that Circle K could bring against them, which they believe
against Valley Tank, right?
No, Your Honor, because Circle K has not brought any claims against Valley Tank.
Right. Well, isn't that your whole, that you want to release? You want Valley Tank released? Isn't that what you're arguing? Or did I misunderstand?
No, Judge, what I'm saying is that if Tank Tech wants to stand in the shoes of Circle K and bring a claim against Valley Tank, Tank Tech needs to show that Circle K's claims against Tank Tech, for which they claim we are liable for, are totally discharged.
Okay, but I'm asking
there's
you, what
no
are Circle
evidence
K,
of that
what would
whatsoever.
Circle K's claims against Valley Tank be? What are
The
those
potential claims are that a tank fails. Any one of these tanks could fail. And as Circle K has already done, they have brought additional claims against Tank Tech.
Okay.
They keep the pleading open.
I want to ask you the same question I asked your opposing counsel. Could you have not made this argument in your first motion for summary judgment?
I believe that the arguments were made, and I believe that the court, I think Judge Isom at the time, I didn't argue that.
You argued complete discharge and release.
Her analysis.
You argued complete discharge and release in your initial motion for summary judgment?
The record shows that there were jury instructions that Judge Isom wanted to have as to the counts when she was preparing her proposed
No, I'm
order.
asking about your motion
And one
for
of those
summary
was that
judgment. I'm trying to understand why we're here again on this. I mean, it's not law of the case as far as I can tell, but you filed a motion for summary judgment. You attacked some of the elements of a claim for equitable subrogation. You got a summary judgment. You came up here, it got reversed, and you go back and you file this thing called renewed motion, and you pick another element and you argue it. And here we are again. I mean, if we reverse again, do you have another element in your pocket that you're going to argue when you go back?
Your Honor, as the case law is abundantly clear, you have to establish all of the elements in order to have the claim of equitable
Right, but do
subrogation.
we have to review them on a piecemeal basis? You get to like file a summary judgment on like, you know, on one element at a time. I mean, it's not, as far as I can tell, it's not law of the case. And but it baffles me that that a party should be able to do this, especially given, the judicial, the limitation on judicial resources, not only here, but in the trial court.
Your Honor, the argument was present, and my client, who's been dealing with this case since 2012, I think has the right to try to bring this case to an end. The
Right.
case has been pending for an incredible period of time. And so we're trying to get to certainty, which, I believe is also in the interest of judicial economy. So, the issue is that they have not been able to prove a number of the causes of action that they've alleged, and there's scant record evidence.
So it's your position then that all the things that we're arguing about today were already argued in the trial court, and that we implicitly decided that in the previous appeal?
Judge, I can't represent that.
Okay, all right.
Counsel, you still have 5 minutes.
Thank you, Judge. But very clearly, when you look at the issue of who's in the best position to say whether or not Tank Tech has certified discharge release, fully paid, whatever, that would be Circle K. And Circle K was very clear in the evidence that was presented to the trial court that the debt was not released, and that Circle K did not intend to release Tank Tech of any further liability. The fact that that liability is uncertain and not quantified or potentially even known reemphasizes the need for some way for Tank Tech to be able to establish that they've fully satisfied or discharged it. And that's why we believe that it is more analogous to a tort case, which would require a release so that there's certainty. Most of the other cases cited deal with a lien or mortgage or an insurance carrier paying a insured's claim. All of those issues are very clearly quantifiable and identified. In this instance, we have a complaint which attempts to be open-ended to claim that we're seeking damages for all tanks we repaired, any other tank that you tested, and keep it wide open. Clearly, there's not 115 separate causes of action.
Judge Kelly, your mic is still muted.
I apologize. I have background noise I'm trying not to subject everyone to. Didn't they attach a list of tanks for which they were trying to seek reimbursement to the complaint?
Yes, but they did not limit their claims to that list. The complaint was very clearly drafted to keep open those listed tanks that were installed at non-Circle K locations and other tanks. So although they attached a list, that list did not define a finite set or there's no circle drawn around that list saying this is all of our damages. This is all we're asking for. It was left wide open. And that's the problem that we run into in the way that they attempted to keep it open, but yet plead purportedly 115 separate causes of action. So based on the record evidence and the testimonies that was presented to the trial court, the final judgment should be upheld. Thank you.
Thank you, counsel. The appellant will have 3 minutes for rebuttal.
Thank you, Your Honor. Judge Kelly, to answer your question, if Valley couldn't figure out from the complaint that the exhibit of 115 tanks attached to the complaint was the circle around which we have drawn this litigation, then certainly Mr. Russell's affidavit, in which he identified the same 115 tanks where Tank Tech paid Circle K's invoices and for which no other claims have been identified by Circle K's own witnesses, that is the circle that we have drawn around this case. And there are 115 because I've counted them. The other thing I would note is that on summary judgment, it's not our burden to prove that there are no other debts to be paid. It is Valley's obligation to prove that all of the debts had not been paid. On summary judgment, they have to prove the negative. Let me go back to the other issue. If our complaint was so poorly drafted after 7 or 8 years that Valley couldn't figure out which tanks we were suing for, certainly the remedy would have been a motion to clarify the pleadings, and the result of this case would not have been summary judgment on all of the tanks that were clearly within the scope, even as Valley would admit, were clearly within the scope of what Tank Tech hoped to sue for. What this comes down to is Valley doesn't like the fact that in this case, we can't just look at a mortgage and we can't just look at a lien and we can't figure out from those documents what the entire debt consists of. We actually have to sit there and add up the invoices. Well, that doesn't necessarily make the damages unliquidated. And furthermore, when Circle K says, and I'll read from the deposition, to your knowledge, for the tanks that were repaired by Tank Tech, so the repair tanks that were then tested were put back into service, are you aware of any claims that Circle K may have against Valley in connection with those tanks? Answer, not that I'm aware of. Have you done any investigation to determine whether or not Valley Tank has any liability at the sites or for the tanks that Tank Tech repaired that were tested and put back into service? I do not. That's on in the record at page 4852. And so not only has Valley failed to meet its burden of showing that there are unpaid costs, but there are no unpaid costs. That's clear from the record. And
Counsel, you would need to sum up quickly in about 30 seconds because the time has expired.
thank you, Your Honor. And to try to extend the release requirement outside of the context of prototypical tort case, of the prototypical tort case, simply doesn't do justice to the policies behind equitable subrogation. Thank you, Your Honor.
Thank you, counsel. Thank you both. That will conclude this presentation. Hope you gentlemen both stay well. That concludes our docket as well today.
Very well,
too,
thank you.
Your Honor.
Thank you.
Thank you.
Okay, I guess we have to go to Zoom.
I think,
Or do we stay here? Or-
I think we're still, yeah, I think we could still be streaming.
So
I don't think I guess we need to get off.
Yeah, I think we should get off. Yeah.